Chairwoman Ray, Vice Chair LaRae, Ranking Member Brent, and members of the House General Government Committee, thank you for this opportunity to provide opponent testimony on House Joint Resolution 9. My name is Gary Daniels, Legislative Director for the ACLU of Ohio. The ACLU of Ohio's opposition to HJR 9 is much less about the underlying policy issue of photo IDs for voters and much more about taking away valuable policy and legislative time to quickly place an unneeded constitutional amendment on the ballot for purely political reasons. Of course, photo ID for voting is already law in Ohio. That was accomplished because of quote-unquote fraud concerns, even though here in Ohio, voter fraud happens so infrequently, is so extremely uncommon, it can statistically and accurately be framed as happening 0% of the time. However, swear to people over and over, there are bad actors behind every corner spending all their waking hours trying to subvert Ohio's already stringent voter ID laws and throw our elections, and some of these people may, at least temporarily, forget their substandard or complete lack of health care, their falling wages, their struggling schools, and continually climbing prices for essentials, utilities, and everything else, among many other concerns. Meanwhile, voting keeps getting progressively more difficult in Ohio as this body chips away at election laws over the years, always to make it more difficult, but never to facilitate voting and expand the number of qualified voters. Indeed, one wonders what HJR 9 authors and supporters intend with the aforementioned language tucked into the end of the resolution that reads, "Nothing in this section requires the General Assembly to pass laws allowing electors to vote in any location or manner other than in person at a polling place on the day of an election." Ohioans overwhelmingly passed an abortion freedom amendment 2.5 years ago. Yet today, numerous anti-choice laws remain in the Ohio Revised Code, obviously in violation of the Ohio Constitution, but untouched by the General Assembly. Over 10 years ago, the Supreme Court of the United States upheld marriage equality for same-sex couples, including here in Ohio. Yet the prohibitions still outlawing or quasi-outlawing it remain in our state constitution and the Ohio Revised Code. The ACLU of Ohio respectfully submits those examples, also involving Ohio's constitution, are just two issues, among many others, well overdue for attention from this body. But instead, here we are debating rapidly enshrining something into the state constitution that is already law, that no one anywhere in Ohio is angling to change, while so much more goes ignored and unaddressed. Again, for purely electoral reasons, not policy ones. For these reasons and more, the ACLU of Ohio urges this committee's rejection of House Joint Resolution 9. Thank you, Mr. Chairwoman.
Thank you, Mr. Daniels. Representative Matthews.
Thank you, Chair, and thank you, Mr. Daniels, for coming in. I appreciate your statement saying it's not with the substance, it is rather than timing and process. But I see, like, the ACLU has consistently said that the Constitution, even when there is statutory protections, that having constitutional protection for things that rise to the level of crucial rights is necessary. And I'll quote from the ACLU's website, without this on why we're supporting the Equal Rights Amendment, even after Title VII, Title IX, the Equal Pay Act, Ledbetter, without the constitutional amendment, those gains are all too subject to the whims of Congress and the courts. Passage of this amendment is the next logical step towards guaranteeing these rights. And I would say that having what we already have here in statutory is great, and is a similar analogy to these types of equal rights amendments, and would think that if it's going to be a process argument, that this totally aligns with the published statements of the ACLU.
Mm-hmm. Through the chair to Representative Matthews, I think the example that you use, and you can find many others of our support for constitutional amendments for this issue or that issue, I think the difference between those examples and this example is that when we do this, we are doing it hoping to make things better. We don't see HJR 9 as making things better, as advancing the ball. We do know that Secretary of State LaRose referred to the federal government for prosecution a year ago, 1,200 cases of suspected voter fraud and voting allegations. admitted by that office was that only 167 of those involved illegal voting over the past 8 years, when 27.5 million ballots were cast. By my math, that is 0.00006% of the time that we have some level of what we think is demonstrated voter fraud of the type that HJR 9 basically addresses. So we see this again as unnecessary with regard to what is going on in context of the world around us. But we'll certainly keep supporting ballot initiatives that we think improve things.
So through the chair, if that's the case, would you like to change your testimony that says that your opposition is less about the underlying policy issues, quoted there from your paragraph, and then later that this is enshrining something in the state constitution that is already law, so then this isn't making anything worse by your statement that this is already the law. So would that mean would you like to update your testimony for the committee?
Through the chair to Representative Matthews, no, the only thing that I think in retrospect where I would like to update or edit my testimony is with some of the wonderful suggestions made from past witnesses and perhaps future witnesses that there are positive things that could go into this resolution that would help facilitate voting. Otherwise, what I'm hoping not to do is sit here, and, you know, I'm willing to do so, but debate about the issue of photo ID itself. That ship has sailed. We're not here, you know, trying to argue the merits of photo ID versus not photo ID. What we're saying is that we at the ACLU of Ohio, we see people struggling mightily every day with a variety of things, and those issues are going unaddressed, and we're spending time here with these discussions. We can work with anybody in this building, in this room, legislators, on particular issues, and would love to be able to do so. We have issues, I think, that at least one that everybody can respond to depending on the person, and so we want to work to make Ohio a better place. We don't see this as doing that.
Thank you. Any other questions? Representative Brian Bailey?
Thank you, through the chair, and thank you for your testimony today. Before you sneak out, Rep. Matthews, thank you for a great question. I thought we were just going to keep getting buzzwords and fill out the bingo card, but I'm glad we're back on track. I do want to ask, for this in particular, you know, the resolution does meticulously limit acceptable photo identification to state issues driver's license, passports, select military IDs, which is fairly narrow as we think of how IDs and things are evolving. But I'd love to kind of hear, as you all have been tracking this at the ACLU, how will permanently kind of lockboxing these IDs from these narrow definitions alter our longer-term voter participation, especially when we're talking about student IDs from our universities, tribal IDs, when we're thinking about mobile workers, or even, you know, low-income Ohioans who frequently have BMV, you know, expired licenses. What are the impacts on our long-term voter participation?
Through the chair to Representative Brian Bailey, it's a good example of what is missing from House Joint Resolution 9 is, you know, perhaps we could be talking about additional IDs. Some of these IDs probably don't, at least in some areas, contain the necessary information for voting, but that could change. I'm thinking particularly of college IDs. That could be, you know, I'm sure you'd have universities out there that say, look, if we don't have the necessary information and documentation, we can do that for the purposes of voting. Maybe it's hunting and fishing licenses. Maybe it's something, anything, to expand the world of acceptable IDs in a way that does not facilitate or allow for or encourage fraud. I'm confident we can do that just the way we do now. But in any of those instances, you're going to be leaving some people behind. Some people who have a whole lot of trouble getting that underlying documentation, whether they're elderly, they're in assisted living, they're in nursing homes, they don't have a whole lot of money, they work 2 jobs, 3 jobs, et cetera, et cetera. These are the types of folks that we see oftentimes get left behind with regard to these types of changes. And so putting something in the Constitution, of course, it makes it very inflexible. You can't, of course, just change it with, the General Assembly passing a bill. You have to go back to the ballot box or a constitutional convention, but of course, we're not going to do that. So, that's always been our overall concern with photo ID, is that there are some people who quite clearly are going to be left behind when you talk about continually making Ohio's photo ID laws more and more stringent.
Any other questions? Representative Brent.
Thank you, Chairwoman, from the chairman to the witness, Chairwoman, excuse me, to the witness. Thank you for always coming and providing ACLU's legal analysis of this, particularly when it comes to how elections work. Right now, this resolution is going to basically say that we're only going to be able to vote on Election Day at one location. Where are your thoughts, or where's ACLU's legal analysis when it comes to this language specifically, when it comes in reference to how we are able to use like drop boxes, voting by mail, early voting? These are things that are protected by law, but they won't be protected by the Constitution. What is ACL's legal analysis of those things not being protected in the Constitution?
Through the chair to Ranking Member Brent, I'm not sure it requires I know what you mean, but I'm not sure it requires a legal analysis as much as just sort of an analysis, but you can see where this is all going. This is to keep more people from voting, not facilitate voting. The examples that you talk about are ones that facilitate voting, some of them wildly popular on a bipartisan basis when it comes to voters. But we're not here talking about enshrining that into the state constitution. If that was there, I mean, we would certainly be here pointing it out and celebrating its inclusion, but I think it reveals much of what's going on here. This is to make voting more difficult, not easier. And so, we would love to see changes to everything you mentioned, but not only does it not make those changes, but it has that concerning language that you point out that seems to be greasing the skids for future changes, perhaps future constitutional amendments of this type that will make it more difficult to vote.
I do have a follow-up, Chairwoman. Thank you. Again, to the witness, in reference to lines 39 through 40, particularly when it comes to adding all this to the Constitution, particularly, we have our local board of elections, and the previous witness talked about how they're not properly funded. That's just stating out one statement too. But also particularly our local boards of elections also normally have judicial review when it comes to our provisional ballots and other things. Even when it comes to IDs, they get the final say so. And that becomes our check and balance within the system. What does that look long-term when we don't have that judicial review ability for our local board of elections when it comes to elections?
Through the chair to Ranking Member Brent, what I do know about that in particular, I think it's a very, very similar concern, is what Mr. David had brought up earlier about the lack of funding for our boards of elections. And to hear people come up, because I hear from the same people that you do, that sit back there and listen to people come in and testify on behalf of boards of elections, or they individually have served on boards of elections, and they talk about how much, they call it a crisis, of people, losing experienced people who have been working the polls over the years for many years, that are tired, that are burnt out. There's people hounding them for this reason and that reason, and they have begun to stop volunteering to be poll workers. And that is a very real problem, especially when every year or two we are here changing election laws. So you have people who are very underpaid, serving many hours on a polling, on election day at a polling location, who are then expected to be like sort of quasi-experts on election law at any given time. And so it's just, I think, another example of where action would be welcome from this body to address that particular issue. It would certainly make HJR 9 land at least a little bit softer, knowing that we would have a full team of capable people working the polls on election day, and listening to the elections officials themselves talk about this before this body. I don't think that we are there right now. I think we're slipping the other direction.
Thank you, Chairwoman.
Representative Young.
Yes, thank you, Madam Chairwoman, and thank you very much for your testimony. And I like you when you were talking about specific things. You weren't really talking about a broad review of the bill itself, and I appreciate that. But you did talk about unneeded, the amendments unneeded. And so my question is it the ACLU's position that election integrity is not deserving of a robust constitutional amendment to protect exactly what you talked about?
Yeah. Through the chair to Representative Thomas, it's our contention that this particular issue is not something that needs to be enshrined into the Constitution, because again, I think it's fair to say that statistically speaking, this can be framed as happening 0% of the time. And so to say, well, we've absolutely got to rush and put this into the Constitution the very next election and do it, we see it as exactly what happened with gay marriage 20-plus years ago, with the bail and public safety one, with non-citizens voting and making that a constitutional amendment. These are done to attract certain voters to the polls, is our contention. You know, this isn't our first rodeo here. We know what this is about. People don't like to talk about it. People don't like to admit it. They will deny it, but we know exactly what's going on here.
I don't look anything like David Thomas and Jim Thomas. I mean, you said.
Oh, I'm sorry. I'm sorry. Your
Yeah.
nameplate right in front of me. Sorry, Representative.
I'm actually better looking.
Too many bills, too many committees.
I guess my question then, again, if it's infrequent and you just narrowed it down to zero, just about zero, isn't it even more important to protect it by this amendment? By this constitutional amendment?
Through the chair to Representative Young, we don't think so. We see it as just taking up too much oxygen in the space where we could be doing so much more. It's like putting into the Ohio Constitution, you can't strike people with lightning. You're probably, statistically speaking, more likely to be struck by lightning than have somebody engage in voter fraud of this type that HJR 9 seeks to protect. So we don't see this, again, as a policy type issue. We see this as driven by electoral concerns.
Okay, thank you, Madam Chairwoman.
Yes. Representative Sonnenberg?
Yes, thank you, Chair Ray. Mr. Daniels, thank you for your testimony today. In your testimony, you say that it's your belief, the ACLU's belief, that we should be tackling the numerous and serious problems facing so many Ohioans. And after we all leave here today, it's expected we will only be back here for 2 more weeks before being not back here for a 5-month period. Mm-hmm. And so we're limited, obviously, in time in those 2 weeks with how much we can do. What are some of the numerous and serious problems facing Ohioans that you think we should be discussing instead of this constitutional amendment, which, as you testified, is really not necessary because of the stringent voter ID laws we already have in place? Thank you.
Through the chair to Representative Sonnenberg, respectfully, I won't rattle off an entire list of things here. We got a lot of people to testify. I could go on and on. Outside of the civil liberties realm, of course, there are people concerned about AI, and they're concerned about data centers, and they're concerned about a wide variety of things within the civil liberties and policy realm that we cover. You can talk about, who we put into prison and why. The war on drugs rages on unabated here in Ohio. Government surveillance is out of control at the local and state levels. We've got almost no laws regulating it whatsoever in the state of Ohio, but you've got cameras and facial recognition and everything everywhere else. You've got people who can't get drug treatment in their communities almost no matter how long they wait. Many people waiting an extremely long time to be able to do that. There are a lot of, even just under the civil liberties umbrella, I mentioned too in my testimony, that are sort of like housekeeping ones, like, hey, look, we passed a constitutional amendment protecting abortion. Maybe take those out of state law now. Everything that is in violation of that constitutional amendment passed 2.5 years ago, but we see no action here in this body with regard to that. But we're going to rush to put this one on the ballot.
Just one follow-up. Yeah, I would add to that list gas prices, affordability issues, et cetera, property tax reform, et cetera, actual property tax reform. But thank you for your testimony.
A little outside of my lane, yeah.
Thank you for your testimony.
Representative Russo.
Thank you. Thank you, Madam Chairwoman. Thank you, Mr. Daniels, for being here. And I'm so glad you brought up some of the resource concerns, because in my conversations with our boards of elections in multiple counties and election workers, everyone agrees that the biggest threat to election security and election integrity is not having the resources or the people to actually conduct those secure elections. Yet that is not what this constitutional amendment is at all addressing, is that issue and concern, which will only grow as budget cuts continue at the county level and state level. But my question for you is, under Section 3, it provides, it talks in there that anyone who does not have the proper form of ID will be given, as provided in state law, time to correct that or cure the ballot. Yet it doesn't specify even a minimum threshold for that time. Again, I would point out that current law provides for 4 days to cure those provisional ballots, but we have seen that over the years decrease, as recently as, I think, 2 years ago, it was 7 days. So your thoughts on, again, there's a lot of talk that this just enshrines current law, but it in fact does not provide the protections for someone to cure that ballot, and your thoughts on not specifying at least a minimum time to cure not having a non-expired form of ID.
Through the chair to Representative Russo, yes, you're absolutely right. This does enshrine current law, but I think what's crucially important, as you point out, is what it doesn't say, what it leaves out and what it leaves open to interpretation. The issue of a free or no fee voter ID is certainly one of them. I think certainly what that section anticipates is that at some point perhaps Ohio will pass something resembling the SAVE Act with regard to photo ID. Or Ohio will eliminate free photo ID or no fee photo ID for everybody. The courts might look at that a little differently or skeptically. But one of the things when we read legislation is, what does it say versus what is left out? What doesn't it say? So, I think your concerns are well founded, that there's a whole lot of positive stuff that could go in here, but for some reason it is not.
Representative McLean.
Thank you, Chair. Thank you, Mr. Daniels, for coming in. The question I have is, part of your testimony, you talk about voting keeps getting progressively more difficult in Ohio. You talk about that in a paragraph. Is that correlated in the numbers of Ohioans going out to the polls in the election? Because I'm not seeing that in, what do you mean by that? Getting more progressively difficult, chipping away at election law? We're not seeing that in voter turnout, so can you explain a little bit what you mean by that?
Mm-hmm. Through the chair to Representative McLean, I think it's to really get down to who is voting and who is not voting. There's an awful lot that's not revealed just by looking at the number of voters. I think we have to look at who exactly there is that's left out of that process. I don't know that there's some sort of comprehensive study out there regarding this. It's very hard, of course, to track down people, for instance, that might say, oh, I thought I had the proper ID. I showed up to polls. The poll worker informed me I didn't, but that I could vote provisionally, but I need to get back to the boards of elections within X number of days to cure that ballot so that I will be able to vote. For some people, they just see that as an impossibility or an extreme inconvenience because they have many other things going on in their lives. They can't take off work to be able to go and do that. I know there's an awful lot of people who don't come in and provide that ID with regard to provisional voting at a later date. So, I suspect that some of the people that we would very much like to see voting, that are oftentimes underrepresented in their communities and their government, those are the ones who are suffering the most from these various changes and the changes not made. I think drop boxes are a great example where we'll say, you get one per county. No matter how small the county, no matter how large the county, you only get one. So we're all for, we look at election laws pretty simply. Does it make voting less difficult? Does it make voting more difficult? And if it makes voting less difficult, then generally speaking, again, I'm not trying to encourage fraud or unqualified voters or anything like that, but if it improves voting, we see that as a very worthy, ambitious thing to support, and those are the types of things we support. We don't see this as doing that same thing. We see this as discouraging voting, as putting roadblocks in the way. But again, we're not here really to talk about the underlying policy issue because, as I said earlier, that ship has sailed. It's already state law. Nobody anywhere. It was said in previous testimony, sponsored testimony, there's people out there who, of course, go unnamed, unrevealed, who are trying to change Ohio law in this regard because that's what we've seen in a couple other states. There's nobody trying to do that here in Ohio.
One follow-up.
Yes.
Thank you, Chair. One word you use in that paragraph confuses me, and I want maybe a little bit of clarification on it. You mention expand the number of qualified voters. You're saying we never facilitate voting and never expand the number of qualified voters. You don't use registered voters or finding the people who arguably are should be registered, but for whatever reason are not. You use the word qualified. I guess, can you tell me what you mean by expanding the number of qualified voters?
Yeah, through the chair to Representative McLean, it's making efforts to make sure that those are qualified to vote can actually vote. There's a very good and real example there. Thankfully, here in Ohio, if you are, and few people know this or do it or take part in it, relatively speaking, but if you're in jail, you're able to vote in Ohio. In your election. That's something that, and it's difficult to do. I know people that go in there, they register people in jail, they have them vote absentee, those sorts of things. It's much different for, if you're serving a felony sentence in prison. But, it's an example of, where Ohio could be taking steps and saying, hey, we're looking for more people qualified to vote. We could be doing recruitment efforts about voting rights, what people need to vote. We could be doing it at nursing homes, we could be doing it at homeless shelters, we could be doing it at schools, we could be doing it in a variety of places where voters tend to be underrepresented in the voting population. So we would like to see, ideally, again, the state taking proactive, positive steps, reaching out to people and saying, hey, did you know you can vote? Do you know you need this to vote? Please come vote. If you get turned away and you vote provisionally, this is what you need to do. More education on these types of things is always better. But what I wasn't trying to do really is draw a distinction between qualified and registered. Essentially, I'm using that interchangeably.
Thank you.
Any other questions? Thank you very
Thank you,
much.
gentlemen.